judgment of the matter of Harpur Trust against Brazel.
Lady Rose will hand down this judgment.
This appeal concerns the calculation of annual leave and holiday pay entitlement for workers who work for varying hours during only certain weeks of the year, but have a contract throughout the year. I will use the term part-year workers to describe this category of worker. These workers neither work the full number of hours worked by full-time workers, nor the full number of weeks worked by part-time workers. The particular part-time worker in this appeal is the respondent, Mrs. Brazel, who is a music teacher at a school run by the Appellant, the Harpur Trust. She works a variable number of hours each week, teaching pupils to play musical instruments, and she is not required to work at all during school holidays. She is paid an hourly rate for each lesson she gives. The issue in this appeal is whether the annual leave and holiday pay of part-year workers like Mrs. Brazel should be calculated so as to be proportionate with that of full-time workers. This would mean that their entitlements were reduced to account for weeks in the year when they do not work at all but are not on holiday. The Employment Tribunal said that the law did allow for such a reduction, whereas both the Employment Appeal Tribunal and the Court of Appeal held that a part-year worker's entitlement must be calculated by ignoring weeks in which they had not worked. It is accepted by the Harpur Trust that Mrs. Brazel is a worker within the meaning of the Working Time Regulations 1998 as they applied during the period covered by this appeal. She was therefore entitled to 5.6 weeks of paid annual leave. She takes this during the school holidays as required by her school. Before September 2011, Mrs. Brazel's holiday pay for the 5.6 weeks was determined by calculating her average week's pay in accordance with Section 224 of the Employment Rights Act 1996. Section 224 defines a week's pay as the amount of a worker's average weekly pay in the period of 12 weeks ending with the start of their leave period, but, crucially, ignoring any weeks in which they did not receive any pay. The holiday pay which Mrs. Brazel received therefore took no account of the fact that she only worked in 34 weeks of the year, rather than the 46.4 weeks earned by worked by full-time and part-time employees. I will call this the calendar week method. From September 2011, however, the Harpur Trust changed its calculation method for part-year workers. In line with what was then ACAS guidance, at the end of each term, they calculated the number of hours which Mrs. Brazel had worked, took 12.07% of that figure, and then paid Mrs. Brazel her hourly rate for that number of hours as holiday pay. The maths is slightly complicated, but in short, 12.07% is the proportion that 5.6 weeks bears to the total working year of 46.4 weeks. By treating Mrs. Brazel as entitled to 12.07% of her pay for each term, the Harpur Trust's calculation took into account only the hours that Mrs. Brazel actually worked, therefore providing a holiday figure which was proportionate to what full-time workers would receive. I call this the percentage method. The effect of this change in approach was that Mrs. Brazel received less holiday pay than she had previously. She therefore brought a claim for unlawful deductions from her wages by underpayment of holiday pay. The Court of Appeal, which gave the judgment under appeal before us, concluded in her favour, and the Harpur Trust now appeal against that decision. The Supreme Court unanimously dismisses the Harpur Trust's appeal. The Harpur Trust argue that a part-year worker's leave must be prorated to account for weeks not worked. The regulations were enacted in part to implement the EU Working Time Directive, which remains retained EU law following Brexit. The Harpur Trust rely on case law from the European Court of Justice, where that court was interpreting the provisions of that directive. Those cases, the Harpur Trust say, establish what they call the conformity principle. They argue that this principle requires that the amount of annual leave, and therefore holiday pay, should reflect the amount of work that Mrs. Brazel actually performs. They argue that the calendar week method is more generous to Mrs. Brazel than would be the position under the conformity principle, so that the working time regulations are not compliant with the directive as they should be. The Supreme Court concludes, however, that the European case law does not have the effect contended for by the Harpur Trust. Although the European case law suggests that, in general, the minimum entitlements prescribed by the Working Time Directive are calculated by reference to work actually carried out by the worker, this does not prevent a more generous provision being made by domestic law. It is therefore not necessary for Mrs. Brazel's entitlements to be strictly tied to the amount of work she actually performs, nor proportionate to the entitlements of full and part-time workers working regular hours. The Harpur Trust suggested two alternative methods for how the domestic provisions could be construed to reduce Mrs. Brazel's leave entitlement to reflect her not working each week in the whole working year. The Harpur Trust say that by adopting one of these methods, although Mrs. Brazel is better off under the calendar week method, other workers working other irregular hours patterns will be worse off under the calendar week approach than under Harpur Trust suggested methods. But the Supreme Court identifies multiple problems with the Harpur Trust proposed methods. First, they are directly contrary to the statutory method set out in the working time regulations in a number of ways. The incorporation into the working time regulations of the definition of an average week's pay in the Employment Act 1996 for the purposes of determining holiday pay, including for those who work very irregular hours, was a choice made by Parliament. The choice was that this should be calculated in accordance with a 12-week reference period, ignoring weeks in which no pay is received. And there is nothing in the statutory language which indicates that the regulation should be construed so as to permit the alternative methods of calculation proposed by the Harpur Trust. Secondly, the two methods proposed by the Harpur Trust would require complicated calculations, requiring all employers and workers to keep detailed records of every hour worked, even if they were not paid at an hourly rate. Finally, the Supreme Court also rejects the Harpur Trust's contention that the calendar week method leads to an absurd result, whereby a worker in Mrs. Brazel's position receives holiday pay representing a higher proportion of her annual pay than is received by full-time or part-time workers working more regular hours. A slight favouring of workers with a highly atypical work pattern is not so absurd as to justify the wholesale revision of the statutory scheme which the Harpur Trust's alternative methods require. The Supreme Court therefore dismisses the appeal.
Judgment in the matters of H.A. Iraq, R.A. Iraq and A.A. Nigeria against the Secretary of State for the Home Department.
Lord Hamblen will hand down this judgment.
This is a summary of the Supreme Court's decision in the appeals of the Secretary of State for the Home Department in the case involving H.A. Iraq, R.A. Iraq and A.A. Nigeria. By way of background, these three combined appeals involving individuals referred to as H.A., R.A. and A.A. concern the statutory regime governing deportation of foreign criminals under Section 117C of the Nationality, Immigration and Asylum Act 2002, the 2002 Act. A foreign criminal, for the purposes of these appeals, is a person who is not a British citizen, who is convicted in the UK of an offence, and who is sentenced to a period of imprisonment of at least 12 months. Foreign criminals who have been sentenced to terms of imprisonment of at least 12 months, but less than 4 years, commonly referred to as medium offenders, can avoid deportation if they can establish that its effect on a qualifying child or partner would be, quote, unduly harsh. See Section 117C5 of the 2002 Act. I shall refer to this as the unduly harsh test. This exception to deportation is known as Exception 2. Exception 1, which is not relevant to these appeals, relates to the length of lawful residence and integration. Foreign criminals who've been sentenced to terms of imprisonment of at least 4 years, commonly referred to as serious offenders, can avoid deportation if they establish that there are, quote, very compelling circumstances over and above those described in sections 1 and 2. See section 117C6 of the 2002 Act. I shall refer to this as the very compelling circumstances test. The very compelling circumstances test requires a full proportionality assessment to be carried out, weighing the interference with the rights of the potential deportee and his family to private and family life under Article 8 of the European Convention on Human Rights against the public interest in his deportation. A principal legal issue raised by these appeals in relation to the unduly harsh test is whether the Court of Appeal erred in its approach by failing to follow the guidance given by the Supreme Court in its 2018 decision in KO Nigeria against Secretary of State for the Home Department, and in particular by rejecting the approach of assessing the degree of harshness by reference to a comparison with that which would be necessarily be involved for any child faced with deportation of a parent, the so-called notional comparator. The principal legal issues raised by these appeals in relation to the very compelling circumstances test are the relevance of and weight to be given to rehabilitation and the proper approach to assessing the seriousness of the offending. In relation to each appeal, the first-tier tribunal allowed the appeal from the Secretary of State's deportation decision. The first-tier tribunal decision was set aside by the upper tribunal, which then remade the decision and dismissed the appeal, and the Court of Appeal allowed the appeal from the upper tribunal's decision. In its judgment, the Supreme Court unanimously dismisses all 3 appeals. I give the judgment with which all the other members of the Court agree. The reasons for the judgment. The unduly harsh test. The Court rejects the Secretary of State's case. The Court of Appeal failed to follow KO Nigeria in the case of HA and RA by not applying a notional comparator baseline against which undue harshness is to be evaluated, and wrongly lowering the applicable threshold. The judgment in KO Nigeria, considered as a whole, makes clear that no notional comparator test was intended. The correct approach is to follow the guidance which is stated to be, quote, authoritative in KO Nigeria, namely the direction given in the upper tribunal case of MK Sierra Leone and Secretary of State of the Home Department. That direction said, quote, unduly harsh does not equate with uncomfortable, inconvenient, undesirable, or merely difficult. Rather, it poses a considerably more elevated threshold. Harsh in this context denotes something severe or bleak. It is the antithesis of pleasant or comfortable. Furthermore, the addition of the adverb unduly raises an already elevated standard still higher. This direction recognises both that the level of harshness which is acceptable or justifiable is elevated in the context of the public interest in the deportation of foreign criminals, and that unduly raises that standard still higher. It is then for the tribunal to make an evaluative judgment as to whether that elevated standard has been met on the facts and circumstances of the case before it. The very compelling circumstances test. This test requires all the relevant circumstances of the case to be considered and weighed against the very strong public interest in deportation. Relevant factors will include those identified by the European Court of Human Rights as being relevant to the Article 8 proportionality assessment, although the weight to be given to the factors falls within the margin of appreciation of national authorities. Rehabilitation is a relevant factor in the proportionality assessment. In a case where the only evidence of rehabilitation is that no further offences have been committed, then, in general, it is likely to be of little or no material weight. But evidence of positive rehabilitation, which reduces the risk of further offending, may have some weight, as it bears on one element of the public interest in deportation, namely the protection of the public from further offending. The relevant statutory scheme explicitly requires the court to consider the seriousness of the offence in the proportionality assessment. The Secretary of State criticised the Court of Appeal judgment in HA and RA for placing undue emphasis on the sentence imposed as the criteria for establishing seriousness. sentence imposed by a court may well reflect various considerations other than the seriousness of the offence. Where, however, an immigration tribunal has no information about an offence other than the sentence imposed, that will be the surest guide to the seriousness of the offence. Even if it has the remarks of the sentencing judge, in general it would only be appropriate to depart from the sentence as the touchstone of seriousness if the remarks clearly explained whether and how the sentence has been influenced by factors unrelated to the seriousness of the offence. In relation to credit for a guilty plea, that will or should be clear. If so, then in principle that is a matter which can and should be taken into account in assessing the seriousness of the offence, contrary to the view of the Court of Appeal. The other issue raised in relation to the seriousness of the offence is whether it is ever appropriate to place weight on the nature of the offending in addition to the sentence imposed. Whilst care must be taken to avoid double counting, in principle this can be a relevant consideration, and this is supported by the European Court of Human Rights jurisprudence. The individual appeals, H.A. Iraq. H.A. was a medium offender who lives with his partner and their 3 children. The Secretary of State accepted that H.A. has a genuine and subsisting relationship with them. The issue was whether it would be unduly harsh for them to remain in the UK without him. Having analysed the decisions of the Upper Tribunal and the Court of Appeal, the Court agrees with the Court of Appeal that the Upper Tribunal applied the notional comparative test. For the reasons set out above, that is not the appropriate test. The Upper Tribunal therefore erred in law in deciding whether the unduly harsh test was satisfied, and the case will have to be remitted for fresh consideration. R.A. Iraq. R.A. was a medium offender who is married to a British citizen with whom he has a daughter. The Upper Tribunal and the Court of Appeal considered both the go scenario, i.e. R.A.'s wife and daughter live with him in northern Iraq, and the stay scenario, i.e. R.A. is deported and his wife and daughter stay in the UK. The Court of Appeal was right that there was an error of law in relation to the very compelling circumstances test. The Upper Tribunal wrongly stated that the sentencing judge had described the offence as serious, and rehabilitation was not addressed, although it was a relevant factor. Further, given that the overturning of the Upper Tribunal's decision on the go scenario has not been challenged, it would have to be reconsidered, and findings made in relation to it may impact on whether there are very compelling circumstances. AA Nigeria. AA is a serious offender. His partner is a British citizen, C, with whom he has 2 children. He also has a child from a previous relationship. The first-tier tribunal made no error of law, and it was rationally entitled to conclude that the effect of AA's deportation on C and the children would be unduly harsh, and that there were very compelling circumstances that outweigh the public interest in AA's deportation. The Upper Tribunal therefore erred in setting aside the first-tier tribunal's decision, and the Court of Appeal was correct to restore it. In conclusion, the appeals in all 3 cases are dismissed.
Judgment in the matter of the Queen against Luckhurst.
Lord Burrows will hand down this judgment.
This is a summary of the Supreme Court's decision in Crown against Luckhurst. Following a conviction for a criminal offence, the Proceeds of Crime Act 2002, which I shall refer to by its popular acronym POCA, provides for the making of what is called a confiscation order by the courts. The aim of such an order is to take away, to confiscate, the criminal's ill-gotten gains. In order to stop an alleged criminal thwarting a confiscation order, POCA gives the courts the power to make what is called a restraint order, which is a court order freezing the assets of the alleged criminal. Respect for the rights of the alleged criminal demands that a restraint order normally allows the incurring of various expenses from the frozen assets, such as reasonable living expenses and reasonable legal expenses. But under section 41.4 of POCA, legal expenses are not permitted where they, quote, relate to an offence, end of quote, which gives rise to the restraint order. The justification for that preclusion is to stop confiscation orders becoming ineffective because the alleged criminal has eaten into his or her ill-gotten gains in order to pay for the legal expenses of defending proceedings for the offence itself or for a confiscation order or restraint order in respect of that offence. This preclusion does not infringe the rights of the alleged criminal because legal aid is available for all those types of proceedings. The narrow but important question on restraint orders that arises in this case is whether the same preclusion of legal expenses applies where the alleged criminal is faced with a civil claim for a cause of action, such as a tort, which rests on the same or similar facts or evidence as the alleged crime. Do the words in section 41.4, relate to an offence, extend to civil proceedings for a cause of action? The defendant, Andrew Luckhurst, a former professional sportsman, is charged with offences of fraud and theft, but he also faces civil proceedings in the Chancery Division of the High Court based on the same or similar facts. A restraint order was made against him, but he sought a variation of that restraint order so as to allow him to pay £3,000 for legal advice in respect of the civil proceedings. That variation was refused by the judge in the Crown Court on the basis that section 41.4 of POCA precluded allowing such legal expenses. Mr. Luckhurst appealed to the Court of Appeal, which reversed the decision in the Crown Court and varied the restraint order so as to allow Mr. Luckhurst to spend £3,000 from the frozen assets on his civil legal expenses. The Crown, that is the Crown Prosecution Service, now appeals against that decision of the Court of Appeal to the Supreme Court. And the point of law, as certified by the Court of Appeal, slightly simplified, is as follows. Does section 41.4 of POCA preclude an exception to restraint order to make provision for reasonable legal expenses incurred by the defendant, where those expenses incurred by the defendant are in respect of civil proceedings founded on the same or similar allegations, alleged facts and or evidence as those of the offence which gave rise to the making of the restraint order? The Supreme Court unanimously answers that question, no. There is no such preclusion, and it therefore dismisses the appeal of the Crown Prosecution Service. The sole judgment is given by myself, with whom Lords Hodge, Kitchen, Hamblen and Stevens agree. I give two principal reasons for the decision. First, on a natural meaning of the words in their context, legal expenses in civil proceedings for a cause of action do not relate to a criminal offence. If one were to ask a judge or lawyer or litigant in such a civil case, which, if any, of the legal expenses being incurred relate to a criminal offence, the obvious answer would be none of them. Indeed, the judge, lawyer or litigant is likely to regard the question as meaningless, because at least normally no attention at all is given to what, on the same facts and or evidence, the position is or might be in criminal law. The legal expenses relate to a cause of action in civil law and have nothing to do with a criminal offence. It might be said that this natural meaning of the words in their context follows axiomatically from the fundamental division between civil law and criminal law. Secondly, it's clear that the purpose or policy of the confiscation provisions is not simply one of ensuring maximum confiscation. Rather, it's recognised that the courts need to ensure that restraint orders do not unfairly prevent the alleged criminal incurring reasonable expenses of certain kinds. Our decision today does not mean that an application to vary a restraint order to permit excessive legal expenses in civil proceedings will be allowed. Rather, as with other expenses, such as living expenses, whether the legal expenses of civil proceedings for causes of action are reasonable so as to permit a variation of the restraint order will be a matter falling within the discretion of the courts. Furthermore, there are two specific indicators that the primary focus of the purpose or policy underlying the preclusion of legal fees in section 41.4 was on the legal expenses of defending the alleged criminal offence and confiscation and restraint orders rather than civil proceedings for a cause of action. The first specific indicator is the June 2000 report of the Performance and Innovation Unit of the Cabinet Office entitled Recovering the Proceeds of Crime, which preceded the implementation of section 41.4. That pointed to excessive legal fees that were being spent in defending criminal cases which were seriously depleting the restrained assets. In contrast, there was no indication in that report or in any other relevant policy document that legal fees incurred in civil proceedings for causes of action were a cause for concern. The second specific indicator, as made clear in the explanatory notes to POCA, is that the availability of legal aid was seen as a quid pro quo, that is, being given in return for section 41.4. In contrast, in the early 2000s, even before the later more significant cutbacks in legal aid, it would be unlikely defendants would receive legal aid for most civil claims, so the provision of state funding would not be a quid pro quo given in return for a preclusion of legal expenses in civil proceedings for causes of action. The Supreme Court, therefore, dismisses the appeal of the Crown Prosecution Service.
The court will now adjourn.